Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 13 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between September 9th, 2020 and September 15th, 2020. We start this week's episode with a civil litigation case. In MB Financial Bank v. Rao, the court addresses whether a financial institution has standing to initiate a foreclosure action on a mortgage in default. The background of this case is as follows. Rao took out a mortgage from SunTrust Bank in 2006. At some time in 2013, it was discovered that the note was missing and a lost note affidavit was executed. In 2015, that note was assigned to MB Financial. That same year, MB Financial filed a foreclosure action based on a default from 2011. At the second non-jury trial, the first non-jury trial found in favor of Rao but was overturned and remanded, the trial court found that while they agree with Rao that neither the note nor the lost note affidavit were physically transferred to MB Financial, they determined that the issue is one of ownership and that the lost note affidavit was held on behalf of and for the use of MB Financial. At issue in this appeal is whether MB Financial had standing to file the foreclosure even though they were not in physical possession of the lost note affidavit. The law states that the holder of a mortgage has the right, upon default, to bring a foreclosure action. A person foreclosing on a mortgage must also own or hold the note. The court found that based on the record produced, MB Financial holds the mortgage and is the owner of the lost note affidavit, regardless of whether they have physical possession, and therefore has standing to pursue the underlying foreclosure action. The ruling of the trial court is affirmed. Next, we get into criminal law, which is the bulk of the cases for this week. Commonwealth v. Way is an appeal following a conviction for possession with intent to deliver a controlled substance. In this case, the defendant was arrested in a parking lot after officers observed suspicious behavior, approached the car, and discovered crack cocaine in the car. There are three types of interactions between police and citizens. The first is a mere encounter, which need not be supported by any level of suspicion, but carries no official compulsion to stop or to respond. The second, an investigative detention, must be supported by reasonable suspicion. It subjects a suspect to a stop and a period of detention, but does not involve such coercive conditions as to constitute the functional equivalent of an arrest. Finally, an arrest or custodial detention must be supported by probable cause. There is no dispute that in this case, the contact was an investigatory detention requiring reasonable suspicion. The defendant filed the motion to suppress, claiming that the officers lacked reasonable suspicion to contact the defendant. At the suppression hearing, the officer testified that he has 30 years of experience as a police officer, 24 working on the narcotics strike force, and has been involved in over 500 drug investigations. He further testified that the behavior he observed was consistent with criminal activity based on his many years of training and experience. He added that the behavior he observed was identical to drug transaction behavior he had previously been involved with. The court found that there was reasonable suspicion and denied the defendant's motion to suppress. Following the conviction, the defendant appealed. The court found that the record supports the trial court's conclusion that based on the officer's training and experience in this case, he possessed reasonable suspicion to conduct an investigatory detention. The judgment of the trial court is affirmed. In the case of Commonwealth v. Hill, defendant Hill is serving a life sentence without the possibility of parole. While in prison, he was charged with a felony and 2 misdemeanors for possession of synthetic marijuana. The defendant refused to accept a plea deal and the matter was being prepared for a jury trial. The trial court judge, sua sponte, meaning without any motion from either party, issued an order dismissing the case. As part of the order, the court stated, "What nobody is asking is why. Is it really worth all this time and cost to taxpayers to tell a life inmate that once he dies, he will have to serve an additional 12 years? The court was clearly frustrated with the backlog of cases where prosecution serves no real purpose as there will be no real consequence to the defendant. The Commonwealth appealed, claiming that the trial court's order violated the separation of powers. Though it seems everyone involved, save for the district attorney, agrees that this prosecution is a waste of time and money, a trial court cannot be permitted to ignore the separation of powers doctrine and to usurp the power of not only the district attorney, but also of the legislature, the Department of Corrections, defense lawyers, and juries as well. The order of the court is overturned and the matter is remanded for trial." In Commonwealth versus Schneider, the defendant came to be involved in an altercation with police after they came to his home for mental health welfare check. Officers knocked on his door and spoke with him briefly. During the conversation, he made some unusual comments. He made no threatening statements or gestures, and there was no indication that he had a weapon or that anyone else was inside the residence. He was dressed, did not look hurt or malnourished, and nothing indicated that he was inclined to self-harm. He then attempted to close the door. One of the officers stopped the door from closing, opened the door further, and went inside. He instructed the defendant to sit down so as to investigate whether further mental health intervention was needed. Unprovoked, the defendant struck the officer in the chest, and a struggle ensued. The defendant was ultimately tased and pepper sprayed. He was then taken into custody. After he was placed in the patrol car, another officer realized she was missing a glove. She went back in the house to search for the glove and discovered marijuana in a glass pipe. The defendant filed the motion to suppress, claiming that entry into his residence was unlawful and all after-obtained evidence should be suppressed. The trial court denied his motion and he was convicted of various charges. He then appealed. The Commonwealth argues that entry was lawful pursuant to the community caretaking exception to the warrant requirement. Pursuant to the community caretaking doctrine, certain warrantless actions of police officers do not offend constitutional principles because they are motivated by a desire to render aid or assistance rather than the investigation of criminal activity. While community caretaking activities are laudable endeavors, they must be performed strictly in accordance with Fourth Amendment protections. In order for a seizure to be justified under the exception, the officer must point to specific, objective, and articulable facts which would reasonably suggest to an experienced officer that assistance was needed. The police action must be independent from the detection, investigation, and acquisition of criminal evidence, and, based on a consideration of the surrounding circumstances, the action taken by police must be tailored to rendering assistance or mitigating peril. In this case, the court found that the facts known to the officer when he entered the defendant's home without a warrant were not sufficient for the officer to reasonably believe that the defendant required immediate assistance. The record supports the conclusion that the officer entered the home because he believed he needed further investigation of the defendant's mental health, and this is not a proper reason under the community caretaking exception. While the court found that the entry into the home was illegal, it found that the evidence related to the assault was not fruit of the poisonous tree. The fruit of the poisonous tree doctrine holds that evidence obtained as the result of illegal police activity or conduct should be suppressed. The court found that the assaultive behavior in the home was not in response to the officers exploiting the illegality of entry into the defendant's home, but rather the defendant's own actions, which constituted a new tree of criminal conduct. However, the conviction is overturned and remanded for a new trial because the jury was improperly instructed that the officers were in the home lawfully, which they were not. While the evidence of the assault is not fruit of the officer's illegality, the marijuana and the pipe are, as they were at least indirectly related to the officer's illegal entry into the home, and those items must be suppressed at trial. In Commonwealth versus Richard, the court analyzes probable cause to search a vehicle. In this case, the defendant was observed driving in an area the officer described as a high-volume, high-drug area. The officer was running the license plate when the car abruptly turned into a parking space. The officer discovered that the car was not registered, so he pulled in behind the car and turned on his lights. The defendant was out of the car and walking away, though two other passengers remained in the car. The officer approached the defendant to speak with him, and he detected an odor of marijuana and noted that the defendant seemed nervous and couldn't tell the officer where he was going. The officer asked him who owned the car, and the defendant told the officer that he had papers on it. The officer asked him to retrieve his paperwork, and upon opening the car door, the officer could smell an even stronger odor of marijuana. The defendant admitted to having marijuana on his person and provided a small baggie to the officers. The officer proceeded to search the car and discovered more marijuana and a handgun in the dashboard console. The defendant filed a motion to suppress, arguing that the officers did not possess the requisite probable cause to search the car. The trial court granted the motion and the Commonwealth appealed. Probable cause typically exists where the facts and circumstances within the officer's knowledge are sufficient to warrant a person of reasonable caution in the belief that an offense has been or is being committed. It must be more than mere suspicion or good faith belief on the part of the officer. Here, the court found that based on the totality of the circumstances, the marijuana discovered on defendant's person, his nervousness and inability to tell the officers where he was coming from, and the strong odor of marijuana coming from inside the vehicle, provided the officer with probable cause to believe that the marijuana was located inside the car and the warrantless search of the vehicle was justified. The decision of the trial court is overturned. We'll be right back with more criminal cases after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Back with more criminal law cases. The defendant appeals from a conviction following a bench trial in the case of Commonwealth versus Brame. Defendant was arrested and charged with possession with intent to deliver and other drug charges after an officer observed a drug deal in a parking lot. The officers were on scene undercover conducting surveillance for an unrelated case. The officers saw the defendant pull into the parking lot and park in a spot far away from the doors. The officer thought this was unusual, so he continued to watch the car. He saw another car pull into the lot and park next to the defendant. He observed the defendant toss a baggie out the passenger window into the other car, and he observed the driver of the other car toss wadded up cash into the defendant's car. The officer, who has extensive experience and training in drug enforcement, testified at a suppression hearing that the behavior was consistent with previous drug deals. After the officer observed the toss, he approached the defendant and stated that he was a police officer. The defendant then drove away and tried to evade law enforcement, but was ultimately boxed in and arrested. The defendant filed a motion to suppress, arguing that the officer lacked the requisite reasonable suspicion to conduct the investigatory detention of the defendant. The trial court denied the defendant's motion to suppress, which leads to the instant appeal. To maintain constitutional validity, an investigative detention must be supported by a reasonable and articulable suspicion that the person sees is engaged in criminal activity and may continue only so long as is necessary to confirm or dispel such suspicion. The Superior Court found that the officer articulated specific observations that showed defendant's involvement in criminal activity prior to the officer's initial encounter. Specifically, he observed the exchange of suspected drugs and money in a practice common to other drug transactions he had previously observed. The observed transaction took place in a high drug trafficking area, took only a short amount of time, occurred in a portion of the parking lot away from the building entrance, and involved individuals who did not communicate to each other. Additionally, the transaction involved two individuals whose automobile registration profiles fit parameters of previously known drug dealers and buyers. Based on the totality of the circumstances, the officer possessed reasonable suspicion, and the decision of the trial court is affirmed. Commonwealth v. Betts is a case addressing right to counsel in a Post-Conviction Relief Act, or PCRA, proceeding. In this case, defendant was convicted of various crimes at trial. He filed a direct appeal in which the trial court rulings were affirmed. He then filed a pro se PCRA petition claiming ineffective assistance of counsel. He was appointed PCRA counsel who filed a supplemental PCRA brief. Following a hearing, the PCRA court filed a notice to dismiss. Immediately after receiving the notice to dismiss, the defendant filed a pro se objection claiming that his PCRA counsel was ineffective. A hearing was held where the defendant wished to address his PCRA counsel's ineffectiveness, but the PCRA court declined to address that issue. Instead, they asked the defendant if he could afford to hire private counsel, if he wanted to continue with his appointed counsel, or if he would proceed pro se. At that time, the defendant elected to proceed pro se. The PCRA court ultimately dismissed the PCRA petition. This appeal followed. The court, in reviewing the record, determined that the right to counsel extends throughout the entirety of his first PCRA hearing. In this case, the PCRA court failed to appoint new counsel after defendant timely raised objections to his appointed counsel's ineffectiveness. As a result, the defendant is entitled to a remand for appointment of substitute PCRA counsel to address the claims of ineffectiveness by his previously appointed PCRA counsel. The defendant in Commonwealth v. Kemick was charged with and pled guilty to a number of burglary and theft-related crimes. In the incident case, the defendant filed a motion to dismiss for double jeopardy and failure to comply with compulsory joinder rules. The court had a hearing where counsel presented argument, but no testimony was taken and no findings of fact or conclusions of law were made by the court. The court ordered briefs on the matter and ultimately denied the defendant's motion to dismiss. The defendant appealed, which is proper, as an order denying a motion to dismiss for double jeopardy grounds is considered a final appealable order. Here, the Superior Court found that the trial court erred by failing to develop a record and failing to memorialize its findings of fact and conclusions of law. The matter is remanded to the trial court with instructions that the court shall conduct a hearing on the motion to dismiss, and at the conclusion of the hearing shall state on the record its findings of fact and conclusions of law and enter an order in accordance with those findings. That does it for criminal law this week. Up next, a case discussing an open records request under the Pennsylvania Right to Know law. Payne versus Department of Health is a case addressing an Office of Open Records request. In this case, the company BCI2 filed an application for a medical marijuana grower processor permit. The application was rejected because it was missing a signature on a document. However, per the Department of Medical Marijuana, each application is reviewed in a 4-part process. During the 3rd stage, a committee of experts give the applicants preliminary scores in various categories. After the scores are completed, the final and 4th stage, the permitting stage, begins. It is at this point that the incomplete applications are rejected. Payne, an attorney, requested the scores given to BCI2 through an open records request. The request was denied. The medical marijuana office stated that the scores were excluded under the pre-decisional deliberations exemption under the right to know law. In order to establish the applicability of the pre-decisional deliberations exception, an agency is required to show that the information is 1. Internal, 2. Prior to agency decision or course of action, and 3. Deliberative in character. Here, the court found that the scores provided during the 3rd phase of the application review process failed to meet the requirements of the pre-decisional deliberation exemption. The court concluded that only confidential deliberations of law or policymaking, reflecting opinions, recommendations, or advice, are protected as deliberative. The court added that because the medical marijuana office released the score sheets and final scores of dozens of other successful applicants, the office could not claim that such scores are confidential. In addition to the pre-decisional deliberation exemption, the medical marijuana office also argued that the information was exempt under the right to know law under a temporary regulation that states that the names and information relating to persons reviewing permit applications, including a reviewer's individual permit application review and notes, are exempt from disclosure. Here, the court found that the scores are not the notes or work of an individual, but rather a score assigned by the evaluation committee, and as such are not protected under the temporary regulation. The court added, however, that any individual application review notes and comment can be redacted from the score sheets that must be disclosed. The final case of the week is a workers' compensation case. In Gabriel versus Workers' Compensation Appeal Board, the claimant asserts that he is entitled to attorney's fees because the employer failed to file a Notice of Compensation Payable, or an NCP, within 21 days as required by the Act. Factually, the claimant was injured at work in February 2016. His employer was notified on March 7, 2016. The employer paid medical expenses but did not file the NCP. Claimant was required to file a claim petition because the employer did not file any proper notices as required. The employer then denied all the allegations in the claim despite being aware of the injury and already paying expenses. The initial workers' compensation judge granted the claimant's petition but declined to award attorney's fees. The law states that attorney's fees shall be awarded and may only be excluded when a reasonable basis for the contest has been established by the employer or the insurer. In this case, the employer argues that the NCP was not required because they had already paid the medical expenses. However, timely issuance of an NCP allows for utilization review of treatment and keeps the burden of proof on the proper party to prove what would otherwise not be possible without an NCP. Here, the court found that the employer violated the Act when it did not timely issue an NCP, requiring the claimant to file a claim petition in order to force the employer to comply with the duties under the Act. The employer presented an unreasonable contest to the claim petition, and therefore attorney's fees shall be awarded to the claimant. Once again, thank you for joining us with the Pennsylvania Case Law Update While You Drive podcast. Have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.